Hey everyone, it's Our Shawn McBride. Welcome to another edition of McBride Attorneys Law Show. Today, we're going to be jumping into handshake agreements. You know, when two people come together and shake hands and agree to do the deal together and walk off, perhaps as gentlemen and have a gentleman's agreement to do a deal. What are the real issues with handshake agreements? And it's probably not what you think. So we're going to jump into that today. And we're going to think about what some of the real issues are when two people come together just with a handshake and agree to do a deal together. So a lot of people think the problem with a handshake agreement is that it's not in writing. And that's part of the problem. That is the surface level problem, is that a handshake agreement is not written down. So we don't know what the parties agreed to. We have a hard time proving later that there was an agreement. Technology has helped a lot with that. And because we can now piece together by emails, by text messages, by other stuff that there may or may not have been an agreement. So technology and just the way we keep electronic records has actually helped us prove that there's a lot of agreements. So that's one reason we wanted a written agreement. It's just to have that memorialization that, yes, we indeed did have an agreement. We came together and we had a meeting of the minds, right? So in order to have a contract, you need offer, acceptance, and consideration. And that's fancy lawyer speak for saying somebody has to offer something, somebody has to say, yes, I agree to that offer, and then there has to be consideration or money going both directions, right? So as part of the business deal, in order to even have a contract that's legally enforceable, we have to have those elements. Somebody has to say, hey, let's do something. Somebody has to say, yes, I agree that we're going to do that something, agreeing essentially on exact terms, and then you have to move forward. So we want a written agreement for that purpose. But the big gotcha hidden there. So let's get into what really is hidden in these agreements, which is a lot of times people, if they do a handshake agreement, don't have the same intention of what they're agreeing to. Let me back up. They don't have the same intention of what they're agreeing to. They say, yes, we agree. One of the things that when we do written agreements, we do is we force everybody to think through the questions, right? And think through what that means and what they're really agreeing to. And if you've ever been through a merger or a customer agreement, there could be a lot of questions pop up when the written contract gets circulated. People start saying, hey, do I agree to that? What about that provision number 6? I don't agree to that indemnification. What about your liability? A lot of devils can be in the details, right? So we got to be very cognizant of the fact that devils can be in the details. And we want to be very careful about how we structure those agreements. So as such, we have to know that when we have a handshake agreement, that we don't necessarily have everybody agreeing to the same terms. I see this a lot with LLC agreements. LLC agreements are essentially contracts among the owners, or what most states would call the members of the LLCs. The members come together. When we write out the partnership agreements, we end up having to force a lot of discussions about who gets what distributions. How do we make decisions? What happens if we disagree? What happens if people want to go different directions in the future? We have to put all that in writing. And you'd be surprised, perhaps, how many deals fall apart when we get into the details. These are people that thought they had a fundamental agreement, but when forced to reduce it to writing and really spell out what the business deal is between parties, they have a difficult time doing so. And so that'll happen a lot with contracts. When it actually comes time to write down who's paying what, when, where, because that's the other thing you need in contracts is you need specificity. We talked about offer, acceptance, consideration earlier in the video. Well, in order to have a valid offer, it has to be clear what's offer, right? I will deliver you this car on this date at this time at this location, right? Those kind of details. A lot of times we'll see agreements where, let's think about a car sale, taking out of the business context, but I will sell you my car. Well, are you going to deliver the car on Friday? You're going to deliver it on Saturday? You're going to deliver it next Sunday? You're going to deliver it a year from now? that could be a very material term for determining whether you want to purchase that car, right? What if you need a car now? What if you need to get somewhere? Delivery can be very important, particularly in business and industrial contracts, right? What if you need something now so you can continue your business operations? My father used to run a warehouse for parts for a steel mill. And as you can imagine, if the steel mill shut down, delivery term becomes very important, right? We need that part now because we have an entire steel mill that's shut down that's not running. So delivery becomes very important. So we have to spell out all the details. That means our contracts, when we have handshake agreements, we need to spell it out in great specificity. And this is really where lawyers come in, right? A lot of people say, oh, go grab the form contract. And I have some videos here on the McBride Attorneys Law Show if you want to go check them out about form contracts, LegalZoom versus using a lawyer. And that's really where the value added of hiring an attorney is. And of course, I am an attorney. As I always remind folks, I'm not your attorney by virtue of doing this video. I can't give you legal advice over this form because it's not that type of relationship. But I give you general ideas to discuss with your lawyer. And so when you're discussing with your lawyer, a lot of the value they add is adding those details, common situations that come up, problems that arise, who has liability for what, allocation of risk. These are the types of things that do not get addressed when people just say, hey, let's be business partners together and everything's going to be great. The other thing that's not addressed in the handshake partnership agreement, because that's where a lot of my work is, I see a lot of it. When we have two partners come together with a handshake, and one thing they're rarely talking about is what if we disagree in the future? Because usually it's in the honeymoon period when partners are coming together, right? Everything's great. There's money to be made. There may be proof of concept of a new business. Everybody's happy about the prospects for the future. Nobody's thinking about the problems. Nobody's saying, hey, what if we disagree? What if one of us wants to build the business and one of us wants to make the business a lifestyle business? Right? We have to balance those competing interests in our lifestyle in our business. So very important that we understand kind of where we're falling. And handshake deals just don't force us to have that rigidity and have those discussions. Another ancillary issue, of course, with handshake agreements is there are the statute of frauds in many states, which requires that certain contracts, sale of real estate, sale of goods over $500 under the UCC terms, certain items have to be in writing in order to be legally enforceable, right? So you can't even bring a breach of contract action in certain cases if you don't have that. Now, there might be claims for unjust enrichment or other ways of getting your money back in the event that you've been swindled by somebody, right? So let's say you pay for something in an unwritten contract and the other side doesn't perform. The statute of frauds may block you from enforcing that contract. So it's really something to think about. However, that's why you get a lawyer. There may be other theories or other ways to get recoupment or get your money back. So you really want to be careful about it. But the big issue that we've focused on today, and the thing I really want people thinking about, whether you're entering into that next handshake agreement or whether you've already been in a handshake agreement, is the fact that the writing isn't there and you weren't forced to go through the rigidity of thought of what's in the agreement and what's not in the agreement. What's the answer? Well, if you're already in that handshake agreement, you need to do an evaluation with your attorney about whether it's worth going back and reopening that negotiation. You could probably amend your oral agreement into a written agreement and use that written agreement to memorialize what you've understood. If you're in a new agreement, now again, get your lawyer, paper it up, really go through the rigor of going back and forth. You will learn a lot in the exchange of should we enter into this contract or not. Just that back and forth between individuals of, what are we agreeing to? What is the delivery date? What happens if something goes wrong? Who pays who? How do we get paid? What happens if we don't get paid? All of that back and forth is very rigorous and it's very important. So you're probably a business owner or a business leader if you're tuning in today. Make sure you subscribe to the McBride Attorneys Law Show on YouTube. Ring the bell to get notifications because I'll be bringing you more tips and tricks for business owners and business leaders. And make sure, of course, that you drop your comments here. Don't put anything confidential, but I want to hear from you. What issues are you having? What are you developing for the future? How can I provide videos that will provide value to your video, to your business? Let me know here at McBride Attorneys Law Show on YouTube. Make sure you subscribe. Our Shawn McBride, sign off. Talk to you soon.